A federal appeals court has ruled that simply having a medical marijuana card will keep you from being able to own guns, even if you don't use cannabis. Let's take a look at why the court's decision is painfully hypocritical given state laws. The ruling was made by the Ninth Circuit Court of Appeals in the case of Wilson versus Lynch. It stemmed from an incident in 2011 when a woman named Rowan Wilson tried to buy a gun in Lyon County, Nevada. The owner of the gun store, Frederick Hauser, turned her away because he knew that she had recently obtained a medical marijuana registry card. Now, Wilson's medical marijuana card was from the State Department for Health and Human Services and was completely legal in the state of Nevada. Yet Hauser's action of turning her away was also legal. See, he had recently received a letter from the ATF which said that even if cannabis was being used for medicinal purposes and if it was approved under the state, the user still could not send, receive, or possess firearms under federal law. Why? Because the federal government claims that cannabis is a Schedule I drug. As a Schedule I drug, cannabis is on the same level as heroin, LSD, and ecstasy, which basically means that the federal government sees it as one of the most dangerous drugs that has absolutely no medical value. But compounds found in cannabis actually have been proven to have a variety of medical benefits, including helping people with Crohn's disease and epilepsy, and even killing cancer cells. That's a lot more than you can say about any of the other Schedule I drugs. So is this just some old law that hasn't been updated? Nope. In fact, just last month, the Drug Enforcement Administration had the opportunity to reschedule marijuana, and they refused. While the federal government acts as if marijuana has no medicinal value, 24 states and the District of Columbia have legalized it for medical use. 4 of those states and DC have also legalized it for recreational use, and at least 5 states will vote on legalization in November. The interesting thing about the case of Wilson versus Lynch was that even though Rowan Wilson owned a medical marijuana registry card, she was not a marijuana user, and she testified that she only obtained the card because she supports marijuana legalization. So the federal appeals court isn't just saying that marijuana users can't own guns. They are saying that anyone who even owns a medical marijuana registry card is not entitled to their Second Amendment rights. This case raises a few questions, such as medical marijuana users can't own guns, but the millions of Americans who abuse prescription painkillers on a daily basis can? And with nearly half of the states in this country recognizing the medicinal value of cannabis, why is the federal government still working so hard to restrict access to it? If anything in this video resonated with you, be sure to share it on social media. You can also follow me on Facebook and Twitter, and if you'd like to see more videos like this one, subscribe to youtube.com/WeAreChange.